Welcome to Audio Cultures for Week 8. Our topics representing communities with audio, rights, ethics and protocols. We're going to be looking at ideas around museum sound, ethics in audio culture, rights and intellectual property, Indigenous protocols, and copyright. This week we'll be thinking through some of the ethical issues around audio production. We'll consider the ideas of appropriation, consent, and copyright, as well as thinking through modes of representation, including selection, description, interpretation, explanation, and construction. We'll look at the guidelines and protocols for working with Indigenous Australian music and the issues faced by museum sound designers. Similarly, the representation of cultural groups in a museum context provides a range of challenges for exhibition designers and media content producers. Museum sound, ethics, and rights. We're going to start by looking at sound design and exhibition design. The representation of cultural groups in a museum context provides a range of challenges for the curator, exhibition designer, and media content producer. There are a range of factors for the designer to consider. Firstly, the museum audience. There are different visitor types, age groups, people of different cultural backgrounds. The designer should also consider typical behaviours of their audience in the layout and design of audiovisual and other exhibition design elements. The designer must also consider carefully the function of audio in the museum context. It can be didactic, that is, attempting to teach. It can be provided for documentation of relevant historical events. It can be provided to produce a sense of immersion or engagement in the audience. And it can be provided to illustrate a mood or a scene or a sense of place. There are a range of different types of audio that can be used in a museum context. Music, atmospheres, voiceovers, interviews, narration, historical audiovisual soundtracks, and other documentary audio. We might consider the sound design in the gallery as a kind of soundtrack, and we can use some of the descriptive terms from soundtrack analysis, such as diegetic sounds, that is, sounds that belong in the story world, and non-diegetic sounds, that is, sounds that are added to illustrate or give a sense of mood to the space, place, or narrative that's being produced. The exhibition designer must also consider the selection of audio technologies used to create the sound environment in the space, in the gallery space, but they might also be considering the use of locative media, such as mobile apps or audio tours. And finally, they need to consider how they work with the stakeholders, that is, institutional partners, the venue, individuals from the cultural groups that they're attempting to represent. They need to think carefully about the collaboration processes that they employ and how they might impact the outcome of their exhibition design. And they need to work alongside, or sound designers need to work alongside, other creative producers in the exhibition design process. So I mentioned the idea of diegetic and non-diegetic sounds. Now here I'm looking at the way that these terms have been used by the academic Steffi de Jong in her article Sentimental Education, Sound and Silence at History Museums from the journal Museum and Society. This is linked as one of the extension readings in the Week 8 section. Now, de Jong uses the terms diegetic and non-diegetic in a slightly different way, so not necessarily thinking of the exhibition itself in terms of a soundtrack. She's suggesting that diegetic sounds in the context of a museum or gallery are sounds that illustrate what the past sounded like. They're a way of producing a sense of evidence or documentation of that past sound world. And she uses the term non-diegetic to refer to sounds that suggest how the story about the past should make you feel. She says, sounds are clearly a powerful, if subtle, means to influence visitors' states of mind and responses to exhibits. She also says that while visitors can easily bypass objects, only fleetingly looking at them and not read the museum texts on the walls, for example, the labels, they cannot decide to ignore soundscapes. They cannot decide to be unaffected by them, whether that's a positive response, a negative response, or an emotional response. There's a kind of immersion, an inescapableness of sound when it's presented in a real physical space. These are interesting concepts, and I encourage you to go and check out that article if you're interested in thinking through the role of the sound designer in a gallery or museum context. Okay, so this brings up a bunch of questions about ethics in audio culture. And we're going to start by thinking specifically about ethics in the context of museum sound design. So we missed out on our trip to the State Library of New South Wales, where we would have seen some really interesting and innovative sound design work in use there in their galleries. But I'm sure you've all had some experience or some exposure to the use of sound, whether it's just audio-visual soundtracks or whether it's some more sophisticated sound design in the context of galleries and museums. I certainly encourage you next time you go to one of these venues to listen more carefully, thinking in terms of the challenges that are presented to the sound designers producing that material for that context. So audio designers in museums must make choices about what to include or exclude and who to consult to ensure that representations and interpretations are appropriate and accurate. Audio designers must take care of the rights associated with sound recordings used. So we're going to get into understanding some of these complicated terms, ethics and rights and so forth. But let's just stop and think about the concept of audio culture. Now, we've questioned this at various points throughout the semester, and this is another point where we get to ask practical questions about what audio culture is. So in the context of museum sound design, an important aspect of audio culture is the rules that determine the use and production of recorded cultural artifacts such as music and traditional and digital media. So one aspect of audio culture are rules and regulations. These in turn influence how a musical culture represents itself and can be represented, or how a culture allows itself to be represented. So we've introduced this term ethics, which I'm sure you've heard before. One way of defining this term in broad terms, ethics are the principles that guide our actions. The ethics of audio relate to how we make judgments or choices. So ethics in broad terms is about the process by which we make judgments or choices. So specific to audio, it's about the ethics of how we make judgments or choices about what we record, how we go about recording, how we deal with the audio recordings once they've been made. Now, there's two sides to how we deal with audio recordings. There's the ethical judgments that we make as individuals, but then there's also a set of rules and regulations that regulate how we can go about doing these things legally. So this brings up the question of rights. So rights are related to ethics. Rights are one of the concepts related to ethics. A right is a moral or legal entitlement to have or do something. So a moral entitlement is something that we base on our judgment of what is right and what is wrong, or what is broadly considered to be right and wrong, or good and bad. And legal entitlements are those things that are enforced by the legal system and the penalties that it provides. Legal rights influence our ethical judgments and actions. Now, we don't always choose to follow the rules of the law, and you may have had experience of ambiguous judgments where you've had to think about whether to copy and collect recorded music. So this brings us into the realm of copyright. Now, I want you to just stop the movie at this point and think to yourself what your understanding of copyright is. Get out a pencil and paper and write down all the things that you know about copyright. Okay, how did you go? I'm guessing you produced a list of different elements of copyright. I hope you stopped and thought about it before we go on. Trying to engage with these videos in a reflective way is one way to try and absorb some of the information that comes from them, so that they don't just fly past with you not remembering much. So try and pause the video whenever a new idea is presented and try and think how it relates to what you already know. So we start our explanation of what copyright is by considering this idea of the work of music. So the word work here has a bunch of different meanings, and unpacking those meanings can help us to understand the historical development of the concept and the application of copyright. So there's two specific meanings that I've got in mind. So we can think of the work of music like a work of art, a composition, which traditionally would have been written down in a score. So we think of this as a specific work. We might think of Beethoven's Fifth Symphony or a particular pop music track and its recording as a work, a specific entity that we can deal with. We can make copies of it, we can play it to an audience, we can buy it in a shop. But there's another meaning behind the idea of work, and that has to do with labour, creative labour or artistic labour, the work that is undertaken by the artist, the composer, the musicians in developing a new piece, a new original piece of music. So both of those concepts around the idea of work are built in to this term intellectual property. So we can think of property as, the objects that you own. You own a guitar, that's your property. Nobody can take it from you. So there's this other concept here of intellectual property, which is a kind of immaterial property. It's not a thing that you can hold on to and lock up in your house. And a work of music is intellectual property based on the two different meanings of the term work. Firstly, there is the piece of music that you have written down the score of. That's your property, that score, or recorded, that recording becomes your property. And secondly, the idea that intellectual property arises because of intellectual labour or creative labour. And these are the things that are protected in the concept of copyright. So if we want to think about the historical origins of this idea of an individual owning intellectual property, we might start by looking at ancient Greek literary contests. So these started around 400 years before the Common Era. And at that time, these literary contests, usually engaged in by the famous playwrights, Euripides and so forth, resulted in their authors being acknowledged as the sources of those texts. And as a result of being recognised as the author of a story or a play, a drama, it meant that you could be protected from, or at least those who wanted to copy or plagiarise your work could be recognised as having taken that work from you as the original author. Now, there's probably other examples of this idea of individual authors being recognised as the sources of new creative intellectual property, but this is as good a place to start as any. It shows that this idea of intellectual property follows the trajectory of modern Western civilization. We can speculate that prior to the historical emergence of the significance of authorship, which emerged with written language, works of music were shared and performed, and their origins were dispersed in a culture. So we might think of traditional folk music, for example. We don't know who actually wrote it. Its origins are lost in the history, in the mists of time, if you like. And, we might think of traditional Irish folk tunes, for example. They belong to that culture. Now, traditional Indigenous Australian culture, some Indigenous Australian musical cultures demonstrate this, how this happens. So the music, the stories, the song lines, if you like, belong to a people, to a particular group. They don't belong to individuals. Now, there might be certain rights and responsibilities that fall to individuals who are owners or caretakers of particular stories or songs. But it's more of a responsibility that those individuals might have to transmit that musical material appropriately than it is a right that the material is attributed to those individuals as an author. Now, that's not true of all Australian Indigenous cultures. There are some where individual songmakers are recognised as the origins of particular new musical works. So let's think about the work of music and intellectual property. Where does the legalistic framework around this, around copyright in particular, come from? Well, the English political philosopher John Locke, who lived from 1632 to 1704, argued that individuals are entitled to control the fruits of their labour. The idea is that the work on some project results in rights to the outcomes of that project that are similar to property rights, and that these rights should be protected in law. And initially, these laws were introduced in England in the 1700s. Now, the important thing here is the acknowledgement of the individual as the source of new intellectual property. And this concept of the rights of individuals is sometimes referred to as liberalism. And John Locke is one of the origins of the idea of liberalism, which is built around the conception of free individuals. One of the things that was concerning John Locke and others in this period in the 17th century was piracy in the book trade. So it was quite common for an author to write a book and for it to be published, and then for another printer to take a copy of that book and make a copy of it, retypeset it and print it without any revenue going to the original author. So to try and stamp out piracy in the book trade in the 1700s, copyright law was introduced in England and other European countries. So you might be thinking that this sounds similar to many of the issues to do with piracy in music and the development of MP3 audio files in the 1990s, and in fact it's exactly identical to the situation that occurred in the 1700s. So it might seem that the protection of an individual creator's rights to exploit and obtain financial benefit from their intellectual labour is perfectly reasonable. And I think for students such as yourselves who are just setting out in the business of becoming professionals in music and sound design, these rights, intellectual property rights, are very, very important to your livelihoods. However, there is currently another kind of movement to do with intellectual property. Contemporary arguments in the form of Creative Commons principles claim that ideas and information are not property at all. They're not like your guitar that you can own and lock up in your house. Ideas and information should be free to circulate in the culture, and that intellectual property laws are in a way artificial, and that they prevent the free exchange of ideas. So this idea is that copyright law is a constraint to creativity. And the Creative Commons movement that has produced a set of very useful licenses that provide a legal framework for the sharing of creative work. So you can see the Creative Commons symbol there that's used often for an attribution license. The Creative Commons movement promotes the free sharing of creative and intellectual property and asserts that restrictions to free sharing are a constraint on creativity and more broadly on human development, that our society, our culture is being held back by the artificial constraints of copyright law. So we might also want to think about these ideas, musical rights and ethics, from an Indigenous Australian perspective, because this can help us to do that kind of shift that the Creative Commons movement has done to think about what other ways of thinking about copyright there might be. Complex and highly structured systems of ownership and transmission rights and responsibilities have existed in Australia for millennia. So I cited the ancient Greeks, 400 years before Christ, as being a kind of origin point. Well, there is another highly complex framework of law that is based in Australian Indigenous culture, and it goes back much, much longer than these principles that we might cite the ancient Greeks as being the starting point of. These systems are linked to identity, kinship, relation to country, and fundamental knowledge systems that govern the management of Indigenous society. So earlier on I said that we were looking for a definition of audio culture, and that one of the things that defines it are the rules and regulations that control how we might handle music, sound and audio. Well, if we look at Australian Indigenous society, we see an incredibly complex system of rules and regulations that control how music, sound, storytelling is distributed, and it's not like a layer of law that's placed over the top of our usual day-to-day behaviours, like we might think of how Western culture operates. It's linked very tightly into how individuals construct, receive, present their identity, their relationships to other people, their relationships to the place that they live and the resources that are provided by that place, and to how they can come to know and what they can and can't be allowed to know. So there's a much more sophisticated, if you like, system of musical rights and ethics in Indigenous Australian culture. And these laws don't necessarily fit easily into either the copyright or Creative Commons conceptions of musical rights. And they're also complicated by the fact that Australian Indigenous cultures are incredibly diverse. And one set of rules and regulations that apply in one region of Australia might not necessarily have applied in other regions. So trying to navigate the world of creating music or creating arts practice with Indigenous Australians, part of that complexity is navigated for us in a way by this document that you can see on the screen at the moment, Protocols for Producing Indigenous Australian Music, produced by the Australia Council for the Arts in consultation with experts from the field. This is a fantastic document, and I recommend you have a look at it. The Australia Council for the Arts proposes 9 principles and protocols for producing Indigenous Australian music. These cover the main ethical concerns in audio culture or sonic culture, plus some specific to Indigenous culture. So if you want to learn some of the things that are important to Indigenous Australians, this is a great place to look. So here are the 9 principles. The first is respect. Respect is a concept that is deeply embedded in Australian Indigenous culture, and we might think about how we use and appropriate musical and other sonic elements rather than thinking of them in terms of how useful they are to us. We might start first by respecting their role and position in the culture of others. The second principle is Indigenous control. That is, Indigenous people themselves should be allowed to control the use of material that originates from within their culture. And a necessary step is to engage in meaningful consultation and obtain consent from the appropriate stakeholders. Indigenous Australians are concerned with the interpretation of musical material that originates in their cultures, and they are also concerned for the integrity and authenticity of their production and presentation. So integrity is an interesting word. It in one sense, it means that all the parts should remain together as an integrated whole, but it's also related to respect. How we behave with integrity. Another interesting principle that we don't often think about from a Western perspective is that of secrecy and confidentiality. Some musical material might be sacred and its use restricted to certain groups at certain times. This material might be secret or sacred material. There are also issues to do with the representation of deceased people, and the protocols for engagement with Indigenous music help us to navigate these issues to do with the representation of deceased people. Another concept that parallels the concepts of music and sound ethics and rights from a Western perspective are the concepts of attribution and copyright. So from an Australian law perspective, attribution is a moral right, and there is also copyright, which protects the ownership. Now, what's specific to Indigenous Australian musical culture is that quite often the ownership doesn't reside with individuals, it resides with whole communities. Another fairly obvious principle is that we should pay for what we use. So proper returns and royalties, there is no reason why Indigenous music should be treated differently to other professional music. Another important principle is a principle that really describes the responsibilities of Indigenous people themselves in terms of their role in the preservation and transmission of their musical culture. And the final principle here is recognition and protection. The Australia Council, as advised by its Indigenous stakeholders and experts, are helping to work towards the legal recognition and protection of musical and other Indigenous cultural artefacts. So they've proposed laws to the Federal Parliament to protect Indigenous heritage rights. So you can see that there are a whole range of ideas to do with ethics and copyright that we can learn from Australian Indigenous culture. Okay, so back to this idea of the work of music and how it's represented in Australian law. So according to the Australian Copyright Act, which was drafted in 1968 and amended several times since then, copyright protection is given in two classes of things. So remember, work can mean things as well as labour. So works including artistic, musical, literary and dramatic works. So copyright law applies to the protection of two classes of things. First is works, and the second is subject matter other than works. So these are the words from the legislation, the federal legislation, including sound recordings, cinematograph works, which is film or video, broadcasts and published editions. So importantly for us, sound recordings themselves are protected by copyright. So there's two things, the composition and the sound recording. Particular rights are protected, and these include the right to reproduce the work in print, film, audio, or audio recording. So this is the list of items from the Australian copyright legislation. Obviously, we're interested here in audio recordings. So the law protects the original creator's right to reproduce the work, and the work, the recording, can only be reproduced with the permission of the artist. They're protected by law. The particular rights are protected, including the communication of the work. So this is an odd term, communication. Communication of the work to the public in performance, playing recorded music in public, broadcast and streaming. So the distribution or the playing of recorded material or works themselves is protected by copyright law. And copyright law also protects the right to make an adaptation of the work. So you can't adapt an existing work without permission from the original creator, without a license. Okay, so we've talked about works and recordings and those rights. There are also other moral rights that exist related to music and sound. And that is, one of them is the right to attribution. So if you're the composer, you have the right to have your name recognised as the composer and for the work not to be used without you being cited as the composer. You also have the right not to be falsely attributed. So if someone is putting your name to a work that you didn't create, that perhaps makes you look less of a composer than you actually are, you have a right to be protected by the law from that. The right of integrity, that is, that the work stays whole and intact unless you provide a license for it to be used otherwise. And copyright obtains in the following aspects of music. So we've talked about the work itself, the composition, and the sound recording. So copyright protects melody and harmony. It protects arrangement, that is, arrangement for various instrumentation. It protects lyrics, separate from the music. It protects sound recordings. And in some jurisdictions, it also protects performances. Now, these distinctions have been developed over the years through case law, and we'll talk a little bit more about that as we go along. So, underlying rights exist in. So, what are the things that you as a composer might have rights to protect? Music. So I've used the term melody and harmony at its most basic element. Melody is one of the core elements that's protected, but current case law has expanded the concept of what musical elements are actually protected. And the 2015 case between the estate of Marvin Gaye and Pharrell Williams in the track Blurred Lines is a really interesting example here. So in that case, which was carried out, I think, in courts in California, the expert witnesses, supported by a jury verdict, determined that something along the lines of the feel of the track, so that was to do with the particular use of percussion, the particular style of vocalization, the arrangement, and even elements of the production, the use of reverberation and echo, were protected by copyright law. To what extent this kind of protection can remain in the future or will be contested in the future, we can only wait to see. Lyrics obviously can be easily identified in written words and they're protected. The master recording itself is protected, and you might have heard of Taylor Swift threatening to re-record all of her famous hits so that she gets back some of her rights in the master recordings, which are actually owned by, were originally owned by the record label and then sold on to a third party that she objected to, but she had no legal way of restricting the sale of her master recordings because she didn't own them in the first place. The musical arrangement is protected. And the point of having these rights protected is to enable you as an individual to exploit financially your intellectual and creative property. So the copyright law enables you or protects your ability to financially exploit your rights, and one of those rights is called mechanical or publishing royalty. Now, the royalties are administered in Australia by by AMCOS, the Australian Mechanical Copyright Society, which is a part of APRA, the Australian Performing Rights Association, and the Australian Mechanical Copyright Society. So mechanical rights are the rights to be remunerated when your original composition is recorded and sold by another party. There are also performance royalties, and these are protected by the Australian Performing Rights Association and the PPCA, the Phonographic Performance Corporation of Australia. So performance royalties cover things like the broadcast of your music on the radio or its use in shops, restaurants, gyms, and so forth. A third way of exploiting your rights is not protected globally by law, but only through negotiation between you as an artist and a record company. And that is the artist royalty. So you will negotiate a specific rate of remuneration, a percentage of the net or gross receipts on sales. And the artist's royalty is not protected by copyright law. If you want to learn more about copyright and get some practical advice on it, there's two really good resources that I can recommend to you. Arts Law Centre of Australia, now you can become a member and they will even provide you with template contracts that you can use to create agreements for small projects, and they can provide you with legal advice on a contract that's offered to you, for example, by a record label. The other general resource is the Australian Copyright Council, and they have a whole range of really useful information resources on their website. So we've covered a lot of territory. We've talked about ethics in audio culture. We've talked about the historical origins of intellectual property rights. We've contrasted those with both the Creative Commons movement and with Indigenous Australian perspectives on rights and responsibilities, and we've introduced some ideas around copyright. I hope this has got you thinking, and I encourage you, if you have any questions about these topics, to share them in the tutorial this week. Okay, that concludes our lecture.